Good morning, everybody. Thank you for attending today's session. You're joining us today on May 15th, 2025 for our webinar, Signed, Sealed, and Voided, Avoiding Common Severance Mistakes in California, presented by Ethos Human Capital Solutions and Merhab, Robinson and Clarkson Law Corporation. Today, we're covering how to avoid the most common mistakes when drafting severance agreements in California. While these agreements can be valuable tools to limit the liability, they're filled with a lot of legal landmines. We'll walk you through what you can and cannot include and how to make sure your severance agreements will hold up under scrutiny. My name is Denise Keddy, and I'm going to be your moderator for today's session. And I just want to give you a couple quick reminders of during our session. The webinar is going to run about 1 hour long. We will have Q&A at the end of the webinar. If you do have to leave before we finish today, we will post the webinar by tomorrow on both the Ethos YouTube channel and the Merhab Robinson channel. So you can go back and find the webinar and the Q&As later. We'll send out the presentation to everyone who joined today in an email tomorrow. If you have questions during the presentation, post them to the Q&A area on the dashboard at any time. If you'd like your question directed to a particular person, please make sure you specify that in the question. If you have any issues during the presentation today, you can drop a note in the chat to me and I'll try to get back to you. Just a quick reminder that our webinar today is being recorded and all accompanying material is protected by copyright. Linda, I don't see your screen shifting. Okay, let me go back to that one. Go back 1 second. Go back down. Okay, to access the handouts, it's okay. To access the handouts, you can download the slides using that link. You'll also get it tomorrow in the email if you don't get a chance for that today. Okay, can you go forward a session? Okay, now we're caught up. Okay. Again, just a reminder, today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today is intended for information purposes only and should not be relied on to reach a conclusion in any area of law. We recommend that you consult with your legal counsel to address your specific situation to ensure you have the most current information on legal matters, or you can reach out to Luna, who I'm going to introduce you to right now. So I'm happy to introduce today Luna Hernandez, who is our legal expert. She's an associate attorney at the firm of Merhab, Robinson, and Clarkson in the firm's transactional department, where she advises clients on real estate, finance, M&A, and most importantly with us, employment law. Luna joined the firm in February 2021 as a transactional department paralegal after immigrating to the United States from South Africa. She was admitted to the state bar in November of 2023 and was recently elected to the Orange County Bar Association's Young Lawyers Division Board of Directors, where she serves as co-chair of the Education Committee. And Luna just celebrated her first Mother's Day this past weekend. So thanks for joining us today, Luna.
Thanks, Denise.
Our our human capital expert is Linda Duffy. She has over 30 years of human capital experience and has built her business and team to deliver outstanding consulting, recruiting, training, payroll, and organizational support programs. Linda and her team are known for building the magic of human connection with your company by developing strategies for business leaders to get the right people, systems, and culture in place in your organization so that you as a business owner can focus on running your business and achieving your goals. And as we talk about in the spring, and when you can't find Linda on a webinar or online, she's going to be at an Angels game cheering on her team. For those of you who have an HR certification through HRCI, this program is approved for 1 hour of credit. You'll get an email tomorrow with the information to receive certification of completion, but the key is you have to answer the quick survey in order to download your certificate. So please make sure you take a minute, answer the survey, and then you'll be able to download your certificate. Luna, would you be able to get us started this morning?
Absolutely. Thank you so much, Denise. So the very first question we are always asked is, must I offer severance payment? And obviously in exchange for the signing of a release. And it's important to know that severance agreements or at least offering severance payments is not legally required. So you do not have to do this. That being said, it's often smart business to do so. This is it allows you to close the loop with a departing employee, ensuring that they won't sue later, and also provides a clean transition for the employee out of your company versus the alternative, which is just terminating and you don't really know where the cards will fall after that. That being said, unless you offer severance and draft your release agreement properly, it can actually increase your risk with respect to claims that the departing employee may have against the company. And that is why careful planning of your offering of severance and the drafting of your release agreement is so important. The offering of severance and the signing of a release also helps the employees transition out, ensuring a smoother, amicable transition. Often we find if you offer an employee a sum of money to help them transition out, it will make them have better feelings towards the company, less negative feelings, and ideally that will keep us in good stead with them going forward, lessening the risk that they go ahead and sue. From the employee standpoint who is actually remaining at the company, it's important to consider how they are seeing you treat employees who have been laid off. Now, that's not to say that you have to provide information regarding any severance payment that you've made to other employees. However, we do and we can cloak in very vague or broad terms things like we're doing the best to support our employees in their transition out of the company. To start off, when you're looking at a severance agreement, we must remember that we are talking about a contract. And in order for a contract to be binding, meaning it will be enforceable in a court of law, there are three essential elements to a contract. We need mutual assent, which is comprised of both offer and acceptance. So the offer of the severance payment, and it would be in exchange for a release of claims. And the acceptance portion is really the employee saying, I agree to the terms that you have set forth in this agreement. And then it needs to be supported by consideration. And Linda is going to go a little deeper into what consideration will be required in the later slides. That being said, it's important to remember that this is an agreement and it needs to be signed by both parties in order to be valid. So there is this miscommunication in business that if an employee signs a release agreement, you can waive all claims under the release agreement. And that is just simply not true. There are claims that can be waived and there are claims that cannot be waived. So in California, employers can settle many types of employment-related claims through the use of a release. The claims that you can release include claims for wrongful termination, defamation, breach of contract, and emotional distress. Other statutory claims are also often releasable, and these are claims such as discrimination, retaliation, or wage violations. There is a caveat to that wage violations release, and that is provided those wages are in dispute, as in we do not agree on the amount of wages that need to be paid. If you do agree and they are owed, you cannot release that particular wage violation claim. So to release unknown claims, you must include specific language from Section 1542 of the Civil Code. And without the use of this language in the severance agreement, the employee can later bring claims that they didn't know about at the time. So one of the essentials you'll see later is we want to always ensure that we include the Section 1542 language. And what the statute requires is the exact use of that language. So keep in mind, if you are trying to draft these agreements yourself, you want to make sure that that language is exact in there. Moving on to the claims that cannot be waived. Some rights can absolutely never be waived. and these include the right of employees to file for unemployment benefits. Severance, the payment of severance and the release of claims does not affect the eligibility of an employee to sign or to request unemployment benefits. Workers' compensation claims must be settled using a special state-approved form, meaning you can't waive an employee's right to file for workers' compensation. Additionally, you can't block employees from filing a complaint with a government agency, even if they have accepted severance. So the EEOC and the California Civil Rights Department, they allow people to report wrongdoing regardless of a release, but financially, they won't be able to recover additional funds. You also cannot waive reimbursement rights under certain provisions of the labor code, such as business expenses or losses caused by employer negligence. And you also cannot waive future claims. Releases only apply to claims known or existing at the time of signing. That being said, you can use warranty language where employees agree that they have no such claims. So what you'll often see in our employment, not in employment agreements, in our severance and release agreements, is that we have the employee warrant that they have not suffered a workplace injury and that they have not filed for workers' compensation as a means to mitigate this risk. If there's any place in a severance agreement that you want to be extra cautious, it is when you attempt to release wage claims. You cannot use a severance agreement to avoid paying wages that are clearly owed. However, if there is a good faith dispute, like disagreement about overtime or meal break premiums, you can release those claims if you pay something extra to resolve the issue. The agreement should state that the employee has been paid all earned wages and is receiving additional value for the release of those claims. To make matters even more complicated, there are special rules for employees who are over the age of 40 years. So the very first question you should be asking when considering presenting a severance and release agreement to an employee is this employee under or over the age of 40? It is not sufficient to use the same severance agreement for both, so you need to be very careful in making sure you ask this question every time. So if the employee is 40 years or older, federal law adds additional rules. They need to be given 21 days to review the severance agreement that's presented to them. And then after signing, or after that 21 days or after signing, they have 7 days to revoke the agreement, meaning you will only pay out on the 8th day after that 7 days has run as a minimum. You must use specific language referencing the release of the age-related claims. And if you're doing a group layoff, there are additional disclosures that are required. Moving on to the group layoffs, when severance is offered to multiple employees, especially as part of a layoff, you're required to provide disclosures under federal law. These disclosures include the job titles and ages of both the employees being let go and those being retained, so the employee can evaluate potential age discrimination. This must be done in writing and is non-negotiable. So if you've ever undertaken this, you'll see there is a table at the end of the severance agreement that will actually list out these job titles and whether the employees are affected or not, along with their ages. Additionally, if an employer is requesting a release of the age discrimination claims as part of an exit incentive or group layoff, the employer must provide the employee with the following: a written disclosure of the decisional unit, which is the group or class of employees considered for the layoff or exit program, the eligibility factors, that is criteria used to determine who was selected and who was not. Remember, you cannot select for illegal reasons. and job titles and ages of all individuals selected and not selected for the program. So this is a lot. The best way to work through this is if you are considering a layoff of 2 or more people, to seek counsel on this so that we can do a proper evaluation to see whether these additional disclosures will be necessary. There are items in a severance and release agreement that just absolutely need to be there. Firstly, you always want to include that there is a right to consult a lawyer. You need to give the appropriate waiting period. So that is at least 5 business days to review the agreement. And in the context of a 40-year-old or older employee, they need to be given, as we had said, the 21 calendar days under federal law, or the 45 in the case of a group layoff. So this applies even when age isn't a factor. You also include a full waiver of unknown claims with the actual text of Civil Code Section 1542. That's the code that I had referenced earlier. This protects us against future surprises. So claims that the employee perhaps didn't know existed during the course of their employment, that they have now waived by virtue of including the Section 1542 language. Another clause that we often see in a severance and release agreement is a confidentiality clause. So an employee agrees not to disclose certain facts. So while it is fine to keep trade secrets and the settlement amounts confidential, California strictly limits how far you can go with respect to this confidentiality provision. You cannot prevent employees from discussing unlawful acts in the workplace or filing complaints with state or federal agencies. If the release includes claims for discrimination or harassment, you need extra language to confirm the employee's right to speak out about those facts. And just as we need to be cautious with confidentiality, we also need to be cautious with non-disparagement clauses. So just in less legal terms, a non-disparagement clause, it means a clause that states, I will not, speak ill about the company. So there are limits to how this particular provision can be drafted. They need to be narrowly tailored. You can prohibit lies, so the employee can warrant that they will not defame the company, but not all negative speech can be prohibited. California requires that any clause restricting discussion of workplace conduct includes specific language that preserves the employee's right to discuss unlawful behavior. And my last slide before I turn over to Linda is we must generally not use no rehire language. So in California, it's generally illegal to include a clause saying that the employee can't reapply or won't be rehired. The only exception to this is if the employee has engaged in serious misconduct and you have gone through the process of documenting the serious misconduct. Otherwise, a clause saying no rehire is strictly off limits. And with that, I am turning it over to Linda.
Thank you so much, Luna. Appreciate that. Hi, everybody. Welcome. So glad you could join us today. See if I can get my slides moved. There we go. So one of the things that Luna mentioned earlier is in order to have a binding contract, we need to have some consideration offered. And what we mean by consideration is you have to provide something of new value to the employee. A lot of times people say, well, I'm going to pay out their wages through the last day, and I'm going to add in their vacation. Will that do it? No, it won't do it, because that is legally already required to be paid to the employee. So when you're putting together a severance agreement, we have to give some sort of additional amount of pay or benefit or service or something that they're not already entitled to in order for this to be legally binding on both parties. So clients often ask me like how much to offer, and my answer is usually whatever it takes, right? If your outcome is to get the employee to sign the agreement, then, think what it's going to take. If I've been there at the company 20 years and I'm making 150,000 and you offer me a week's pay, that's probably not going to get it done, right? So just think through what it can be, and you can be creative about this as well. But the first thing to do is figure out, okay, how much am I willing to give the employee? Because at some point, whatever you're offering the employee, you have to get a return on your investment, right? So if you're going to end up paying hundreds of thousands of dollars to get them to sign it, then probably not worth it. But if you look at it, for example, let's say you carry employer practices liability insurance and you have a deductible that's $25,000 before the insurance carrier is going to pay out. To me, anything up to $25,000 then is a potential win, right? Unless you think this claim or a potential claim would have no value whatsoever. If you're going to get sued and end up paying out $25,000 and then having your rates go up the next year, so forth, then maybe that's your upper limit, right? But it's not just about money. That's the starting point. That's what employees are going to think about is I'm going to need money. But what if the employee needs medical coverage? Maybe you offer to pay their COBRA for a period of time. Or what if they have a laptop that you issued them and you don't really want it back, but they'd like to keep it? That's consideration, right? Include it. So you can get creative about this. It doesn't have to be just cash. I was telling Linda when we were doing our prep that a client once named a conference room after an employee, right? They had been there for a long time. They threw her a going away party and they offered her the chance to basically have a legacy, which is what her ego needed in order to step away from the company. So every employee is different. They have different needs, they have different desires. So figure out what it is for them, and then that's what you can offer. The other thing is how you present it matters. So even if your agreement is legally sound, right, you have to worry about that being invalidated, but you always want to give the employees time, consideration, and let them go see an attorney. And a lot of times our clients are like, oh, I don't want to say they can go see an attorney, but that's required under the law. And I think it's better just to be respectful and be clear with them about what their rights are and what their obligations are, and just be direct with them, be transparent so they understand everything, because that is another requirement. So you don't want to pressure, you don't want to, issue ultimatums or anything like that. The way that we typically present it is basically to say, look, this is a gift from the company. It's not required. This is something the company wanted to do for you, right? We make it very employee focused, very positive when we're there. And we come out and we do these all the time for clients, right? We're there with them. I think it's important for the manager to deliver the news that the person's being fired or laid off. But after they have that part of the conversation, they just turn it over to us and we take it from there. We've done this many, many times. So it's a lot easier for me or somebody on my team to be self-serving on your behalf, right, than it is for you to say, like, oh, I don't have to do this, but I want to do it for you. It doesn't come across to me anyway. It doesn't come across as well as if a third party is explaining that to the employee. So we just say, look, this is a gift. This is something that the company didn't need to do, is not required to do, but the company wanted to do this for you. So we also let them know that the severance will not offset any unemployment insurance benefits they may be entitled to. So we cannot control whether or not they get unemployment, but we have a pretty good sense of whether they'll qualify, right? If they're laid off, they'll qualify. They're fired for performance, they'll like 99% of the time qualify. If you're firing them for wrongdoing, however, they may not qualify. So if they are qualified to get benefits and you're going to pay them out some severance, as long as it's known to be severance, it's not going to offset their unemployment. And that's really important to employees because you can sell it as, this is going to keep you whole a lot longer. So if I'm going to give you, I'll just make it up, I'm going to give you 2 weeks of severance, but you're going to be able to collect unemployment. That unemployment amount is on top of what they are normally earning. So it goes a long way to getting the employee to sign the agreement. Now, Luna mentioned some of the things that have to be included in the agreements. Here are some things that are common pitfalls, right? So, if you don't use the correct template, for example, like last week, one of my clients sent me an agreement and said, hey, can you take a look at this? because we're going to let the CFO go. But what she sent me was somebody for under 40 years, and he was in his 50s. That would not have been good had that, had she actually given that template or used that wrong template with the employee. Forgetting to include that review period. And for people in California, that's 5 business days for California employees. That actually only went into effect a couple of years ago. Up until that point, you could just say, here you go, take it or leave it, sign it now or else, you could do that. And now you cannot do that. So you always want to make sure that you include the appropriate language and the appropriate review period. You cannot ask for a waiver of claims you cannot waive, right? That's the other reason I was telling Luna, we never send a Word doc out to our clients, is because we've had too many instances where they take out information or paragraph, or they try to include something that they're not allowed to do. So you want to make sure that you have somebody review the agreement. There's also failing to clearly describe the claims being waived. There shouldn't be a secret, like I said. You should be transparent with your employees. It goes a really long way. And you don't want to use too much legalese. There's actually a requirement that the employees, it's written basically in plain language, right? If you go on and on with a whole bunch of legalese, or you're using, 25-cent words, and you're dealing with an employee that may not have that vocabulary, that could potentially invalidate the agreement later. So you don't want to do that. Luna mentioned the no rehire clause, and then also not providing, consideration that's above and beyond what is already required is an issue. And then finally, attempting to waive government complaint rights. You're not allowed to do that either. So here are some best practices to follow. Again, use state-specific templates. The template that we have is for California. That's where we normally work with our clients, but we have had to go out and have other templates, other states drafted, because a lot of our clients are in multiple states. You also have to stay on top of the changes in the law. So like I said, until a couple of years ago, there was no waiting period that you had to put in for employees under 40, and now there is. So if you have an old template, you probably don't have the updated language in that. You always want to document when the agreement was given to the employee. I know in our template, there's actually a date that says, this person's getting this as of this date, and then when the agreement is actually due, we spell that out really clearly for them. So they can't come back later and say, oh, I didn't know I had to get it back to you by Monday, right? And we talked to them about that as well. Talked about, make sure it's just plain language. They can understand it, they can read it. And here's my best tip. If you think the employee is going to negotiate the severance, start low. Now, most employees, I would say, don't even know they have that power. We know as business owners and HR people that they do have a lot more power, and the client sitting here scared, like, oh my gosh, what if they don't sign the agreement? So make it enough to get them to sign. But again, if you think that the person is going to negotiate, then offer less than that. So when they come back, they can get the win that they need, right? Because their ego needs to be satisfied that they won in this negotiation. And you're just like, yeah, I would have given them more, but they don't need to know that, right? And then that way they'll go ahead and sign the agreement. And then also just remember, it's all about the employee. It's not about you as the business owner or as the HR person or whatever. The employee is losing their job. It's a big deal, right? And their brain's going to go to, oh my God, how am I going to pay my mortgage, my car payment, my wife's pregnant, my husband just lost his job. Like whatever those things are going through their head, have empathy for that. I learned this as a really young HR person. The very first time I ever did a layoff, I sat in a machine shop with the manager, and he literally started his pitch to the employees. Well, this is going to hurt me a lot more than it's going to hurt you. And I'm like, oh my gosh, no, it's not, right? You still have a job. So remember, it's about the employee. You want to make sure that you're doing everything you can to support them. So just to be clear about some of the severance timelines, because this can be really confusing for people. We have 2 different examples. So on the left, for somebody under 40, you're going to present the agreement on a certain day, right? If it's today, then today is day 0, let's call it, right? Tomorrow, and for 5 business days in California, 5 business days later, that is their review period. And then, excuse me, by day 5, they should have signed the agreement and returned it to you. After you get the signature, whether it is day 1, day 2, day 3, day 4, or day 5, as long as it's by your deadline, then pay the money after that, or give them whatever consideration if it's not cash, right? Give them whatever consideration after that. There's no revocation period. You don't have to wait to see if they change their mind. Contrast that with the timeline example. If you're 40 years of age or older, the government thinks we're old at 40, so they have to give us more time to consider the agreement and then a period of time to take it back. So again, day 0 is the day that you present the agreement, and then days 1 through 21, right? Or days 1 through 45, if it's a group layoff, right? That's when they get their review under the Older Worker Benefit Protection Act. That's what that abbreviation stands for. So they can sign it and return it to you anytime during those 21 or 45 days. But then even if they signed it day 3, there's a 7-day revocation period after that in which they can change their mind. So you do not issue any sort of severance payment or any other consideration until after that revocation period ends. But again, the other thing to know about this and to remind the employee when you're talking to them is, I'm giving you this many days to consider it, but you don't have to take them. Now, having said that, I personally do not like it if an employee says, I'll just sign it right now. Okay, because I've only had this happen a couple of times where they have, I was going to say, invoked the revocation period, but where they've revoked the agreement. And that's when they've signed it on the spot. Like they're getting fired or they're getting laid off. They go, I'll just sign it right now. And then that's when they change their mind because they didn't really think about it. They didn't have time to consider it. Or even more likely, they go home and now they're talking to a spouse or a family member or Uncle Bob, who's a real estate attorney or whoever it is, right? And they're like, oh, no, you should negotiate, or you should, have an attorney review this, or you should do something. So I personally say, don't let them sign it in the moment. But I tell them, if you want to take it home and bring it back tomorrow, then that's fine. But I want to make sure that you have carefully reviewed this and that you have really thought about it. And if you want to go seek, employment counsel, then you should do that as well. So here's some pushbacks that you may hear. So I just want to review these. It's, I will say, not that common for employees to negotiate. Luna may have a different experience, I don't know, but just be ready to respond to questions and pushbacks. You don't want to pressure them. And also a lot of times employers or clients will say to me, well, can we pull the agreement back? Well, maybe, but I don't think that's really a good idea, right? If they negotiate, then just say no. If you don't want to negotiate, that's fine. Or again, consider giving them a little bit more so they feel like they got to win. So sometimes they'll come and they'll say, I need more time. And basically what my advice is let's figure out why they need the more time. If they say to me, well, I know I have 5 business days, but I called my attorney yesterday and she can't meet with me until next week. Can I have another week? Okay, if your end game is to get them to sign the agreement, then why not give them an extra week, right? Don't put the pressure on them to sign by day 5. That would just be my advice. But if you don't want to, if you go, you know what, I don't care if they can get to an attorney or not, there's other attorneys out there, I want it back within 5 days or else, then that's your right to do. Can I remove this clause? Depends on what the clause is, right? Employees may say, well, I don't want this, I don't want that, or I want to change the non-disparagement clause so it's mutual. So they talk nice about me if I'm going to talk nice about them. Then fine, modify something, right? Agree to do something like that because you're not going to talk bad about them anyway, right? But so it depends on what that clause is. So you always, again, should reach out to Luna or to our team or somebody to help you to know if it's a required clause. What happens if I don't sign? You don't get what's included. That's the bottom line there. That's an easy one, right? If they're not going to sign it, then they don't get what's being offered to them. And can I get a letter of reference? So this is a really interesting question. You have to be so careful. So hopefully your company has some sort of guideline on under what circumstances can somebody receive a letter of reference or a LinkedIn recommendation or whatever it is. if you're laying the person off, they're losing their job through no fault of their own, they've lost a contract with the company, something like that, then, I wouldn't have a lot of heartburn over this. You just want to always be really honest in your letters of reference. If the person is not doing a good job, don't offer a letter of reference. Again, I've sat with clients who they don't know how just to be silent, as we're going through the termination meeting. And next thing you know, even though they're firing this person for wrongdoing or poor performance, they blurt out in that moment of silence, like, I'm happy to give you a reference or a letter of recommendation. I'm like, oh, no, you don't. Give them a verification of employment if you want, but don't go through and tell the world, they're so good when they're not good, right? So you just want to be careful about that. But we have written into agreements before that they will have a letter of reference, or they will receive a verification of employment letter or something like that. But just think through what you're actually willing to say. Some final thoughts before we go to Denise with some questions. Here's some takeaways. Severance can protect your business, right? But it has to be done correctly. The last thing you want to do is give them an agreement that's going to be later invalidated. California, they have some unique requirements. You have the requirements at the federal level. It's going to apply to all states, but you have additional requirements because you're a California employer. We all know how that works, right? So you want to make sure that you're aware of both of those. And so if, again, the person's over 40, that doesn't come from California law, that comes from a federal law. So you want to make sure that you're compliant with everything. And then don't cut corners, right? Make sure everything's clear, make sure they have the appropriate time to review, make sure it's legally in legal compliance with all of those laws. And then, seek out some counsel, whether it's Luna, another attorney, us, another HR consultant. Just make sure somebody is looking at your agreements before you use them to make sure that they're up to date and compliant. All right, Denise, hopefully people have dropped some questions into the chat. I moved this slide up because I just wanted to tell people we are looking at June 19th as our next date. We haven't set it in stone, but we're close to it. And we would love to get some ideas from you on what topics you want to see done. So when you go and fill out the survey, and it's like 5 questions, it takes you all of 2 minutes at the most. There is a question about future webinar topics. So please take the time to share your ideas with us, what you think would be really helpful. You can email it to me, or you can put it in the survey response, but we are happy to do whatever you want. And frankly, it gets harder and harder for us to come up with topics because we've done so many and we don't know exactly what you want. So feel free just to share that. The other thing is, in late June on the 27th, we're going to have a public management training. And then I think there's going to be a follow-up date for higher level. So details will follow. We're going to put them in our next newsletter. So just be aware of that. So if you have managers that have never really had any sort of management training and you want them to know the basics about California law and maybe develop some soft skills on how to talk to people, this will be a great opportunity to do it. So we will be sending that out shortly. Okay, Denise, I'm turning it over to you.
Great. That was a lot of information. So while people put some questions in the chat, in the Q&A section, I just wanted to remind everyone who had reached out that you will get a copy of the presentation tomorrow. If you missed it earlier, you'll receive an email. So make sure you're on the lookout for that. Okay, let's see what we have. My boss said he doesn't want to sign the agreement. Can I just remove his signature line and only have the employee sign an agreement? The severance agreement, obviously.
Luna, you want to take that one?
Sure. Well, no, he should definitely not do that because it won't be a binding agreement. We're talking about a contract here, and someone needs to sign on behalf of the company. So please do not only have the employee sign.
Great. Here's another one. I know Linda said that the consideration can be anything the employee isn't already entitled to, but what is a normal severance amount?
Okay, great question. So again, my answer is whatever it takes to sign. But a general rule of thumb I think I've seen over the years is for, we'll say, non-management employees, rank and file, maybe a week per year of service, maybe more if the company is feeling generous. I've seen it different for terminations versus layoffs and things like that. So maybe a week per year of service. If you're a manager, probably 2 weeks per year of service. If you're an executive, 3 weeks or more per year of service. And a lot of executives will have an employment agreement where terms for their termination are built in. So always check that if you have an executive that and you use employment agreements. So you want to make sure if there's anything in there providing for severance upon exit. But keep in mind this too, that's how we usually language it is like 2 weeks per year of service, but it doesn't have to be tied to years of service. You can just pull a number out of your, you know what, and just roll with it. So you could just say, I'm going to give them $5,000. You know that that's roughly, 4 weeks of pay or something like that. But you don't have to even say it to that. You can just put a dollar amount in. So like in our agreement, we don't ever specify like we're going to offer you 4 weeks of pay. I have the client tell me how much is that gross, right? And then we put the dollar figure in. So if the employee is like, how'd you come up with this number? You can explain it to them, but you don't need to, spell it out in the agreement that we're going to offer you 4 weeks of pay. The other thing, and Luna, if you want to jump in on this, feel free. I was telling Luna, I've had companies before who we've actually helped them create, so what I call the Jeff Bezos model, right? Where they just want to offer severance to everybody, whether they quit, they get fired, they get laid off or whatever, just because they feel like that's the cost of doing business. So we actually help them develop policy and a sort of like an amount system, right? Let's call it a point system. If they quit, but are they female? Are they other protected class, right? Are they over 40? Blah, blah, blah. The higher the risk factors, the higher the amount, right? And then a higher amount if we were going to fire them or lay them off. So I've seen it done a whole bunch of different ways on this, but again, it doesn't have to be tied to weeks of service. The other thing I'll say is you do want to be consistent in how you apply the policy. So you don't want to all of a sudden go, well, I'm going to give the white male, a month that's been here a year, but I'm going to give the Black female a week, right? Because then that's going to be a problem for you down the road. Luna, anything you want to add to that?
Yeah, two things, especially when you're looking at potentially disparate treatment. Although you do not need to offer severance to every single employee that's terminated or laid off, we do want to keep in mind that if you are giving something to someone, you are creating a precedent in your company. So you just really need to be thinking through, what steps you should take here. And you can do that with the assistance of either us or some other attorney or Linda or another HR consultant. So that's the first part there. And the second, something I hadn't thought of touching on here is when you had mentioned the amount that's given is the gross. We always recommend that you need to take standard tax withholdings out of the severance amount. And you want to make that very clear to the employee that you are going to do that so that they are under no mistaken impression that they're getting the gross amount. Alternatively, there are ways of drafting that would make them responsible for the taxes on that. There are very specific nuances there, and I like to include some representations in the severance agreement if we do have them sort the tax out on their own. But as a general rule of thumb, I always like to have the employer take out the taxes already.
Yeah, I agree. And just to clarify one thing, severance is actually taxed at a supplemental rate, which is a higher rate. So I'm just going to say that because I don't want people to misinterpret the phrase standard taxes. So yes, standard taxes per IRS code, which says that this has to be taxed at a supplemental rate. Whether you do it or don't do it, that's between you and yours, but just wanted to let you know that because we have had employees say, I don't want taxes taken out. Now, if they want and you want to allow them to change their tax withholding for their severance, and go, increase the number of dependents or whatever, that's again up to you. So they can, fill out a new W-4 that would reduce perhaps the amount of tax. But just be really careful with that. Consult your CPA on that one.
Okay, great. We had a question come in that said, if at our company we eliminate positions, does this fall under the category of a layoff?
To me, yes. You're eliminating a position. If that person's losing their job and it's not due to misconduct or performance or attendance or whatever, I mean, it's probably a layoff, right? I mean, what's the reason that you're letting the person go? So if you're eliminating a position, that's a reduction in force or a layoff. I would use those interchangeably. Luna?
Yeah, same. I have nothing of value to add there.
So if the positions that are eliminated then are with people under 40, do we have to provide the employment list of the ages, position, and title like you mentioned earlier?
You do not, but if even one person that's part of that group is over 40, then yes, you have to issue it to everybody.
Okay. Do the considerations for severance vary between exempt and non-exempt employees?
Not, oh, sorry, you go
No,
for
go for
it.
it. Go for
Uh,
it.
legally, it doesn't have to, right? So again, when Linda had said, come up with a number, this is the same story here. Come up with a number. However, you may find that for an exempt employee, they are likely at a higher level. There may be certain provisions in their employment contract, and you may need to entice them into entering into the severance agreement with a larger sum than you would, let's just say, your regular hourly employee earning ballpark $20 an hour, for instance.
Okay, sorry. Are there extra steps that we have to take when you are laying off multiple people aside from giving the 40-plus-year-old employees 45 days? I don't think they understood that right.
So I would say one of the things that you need to do when you're laying off multiple people is do that disparate impact analysis, right? You take a look at everybody in the department, or if it's company-wide, everyone in the company. And you may not have any intention of discriminating against people, but you have to say, okay, if I Monday morning quarterback this, right? If I look in the rearview mirror and somebody that doesn't know my thinking, right, were to look at the list of people that go, is there a disproportionate number of people with protected characteristics included in the layoff? So did I just take a department that has 10 people in it and I laid off the two, racial minorities and kept the white people, even though that wasn't your thinking? You have to document your thinking behind the layoff, why the people you chose. I'm not saying it's necessarily wrong to let go the two racial minorities in my example, but what I'm saying is without documenting the thought process or the reasoning behind it, it could come back to haunt you later. So what we typically do is, take a look at everybody impacted and just take simple notes. It could be an email to your boss. This is my thinking about, this. Send an email to HR and say, the reason these two people were chosen were like they had the worst attendance or they had the lowest performance ratings last month or whatever it is. You just want to document your thinking behind it. Luna, what else?
And in addition, look at it the other way around as well. Just make sure that you are not making these decisions based on an illegal reason. And I'll use a practical example. I have previously had a call from someone who said, I hired these two employees at the same time, and I think it was their attendance as well. It's as bad as one another. I need to lay one person off. I'm thinking it's the person who isn't about to go on paternity leave. Okay, huge red flag right there. So going through this analysis, you really need to be asking yourself, am I making sure I'm making a decision not based on any protected characteristic?
So many considerations that have to happen. I have another question, but will you do us a favor? Will you back up Linda and put your information on the screen? Your and Luna's information. We do get a lot of questions, and a lot of times they're a little bit more in detail. So the best thing to do for your situation, we mentioned it earlier, is to make sure that you reach out to either Linda or Luna, and there is their contact information so that you can ensure that you are doing this correctly. We have another question. If multiple layoffs happen, so there was a layoff in June, another layoff in March, and then an additional layoff in May, is there a risk that they would be grouped together and fall under the notice requirements?
Yeah, I think so. Luna, you want to jump in here?
Yeah, I think that this does require a little further analysis, and we were kind of wrestling with this question yesterday, and haven't come to like a conclusive answer yet, from my side at least. So I think reach out to one of us so that we can look at your circumstances. But I would say we need to ask the question, at the time that you did the first layoff, like, was it foreseeable that you were going to do the second one? Are you just staggering them in an attempt to avoid giving that full list out? In which case, I would say there's a very large risk that you're doing it incorrectly. Yeah, that's where my mind's at with that currently. What about you, Linda?
Yeah, no, I agree with that. We really looked at that when we were talking yesterday, and reviewing the slides again. And we don't have a specific answer for you because I don't know that the law spells it out. So it's more like we'll know it when we see it, I think, and that's a little bit scary if you ask me, right? So what you cannot do is say, well, I'm going to lay one person off on Monday, one off on Tuesday, one off on Wednesday, because then it's not, it doesn't trigger anything, and that's just not the case. Whether or not laying off groups in, every other month in your example, triggers something, I don't know. But what the law says is if you're laying people off as part of a program, is one of the words they use, right? And you're going to offer like essentially standardized severance. It's not a one-off termination. You're going to offer like everybody that's being laid off, here's the package. And it could vary based on protected characteristics or something, but this is essentially what our policy is. This is part of the program. This is what we're doing. Then that is going to trigger this. So if you have, it could be back to what Linda said, in February, when you decided to do this, you had no intention, but then you lost another contract, so you do it again. And then you agree that the cuts weren't deep enough, so you do it again. I think somebody would make an argument that that's all part of the same thing, or at least the second two are. So again, we can research that, Luna can research that, but you want to have somebody take a look at that and just be careful.
Yeah, and just adding to that point, you have to look at the amount of time it's going to take you to, do the full reconciliation and, excuse me, my light keeps on going off, and producing the list. I think that the amount of time it's going to take you to do that is far less than you will if you end up getting sued because you haven't done it the correct way here. I would say just default to giving the information if you're on the fence about it. Don't try and jump through various hoops to avoid doing it that way. The risk is simply too high.
Great. And then just one other quick reminder, make sure that if you want a copy of the webinar, that tomorrow you can look on both the Ethos HCS YouTube page and the Merhab, Robinson, and Clarkson Law Corp YouTube page. We always post the webinars afterwards so that you can get the information. And so that is it for today. Thank you, ladies, for your information and inviting me to come along on your webinar journey with you.
All right. Thanks, everybody.
Denise.
Have a great day, everyone. Thanks for attending.